Good morning, everyone. We're going to open the work session on our interim study bills today. And we are going to, first of all, we're going to stand for the Pledge of Allegiance. At this time, we're going to start with opening the work session on House Bill 205 relative to the incarceration under suspended sentence. And as this is a work session on whether or not to recommend future legislation or not, at this time I'll open it to members if anyone has anything they'd like to say. Representative Bourdonnais.
Thank you, Chair. My understanding is that when we discussed this and the last time we discussed it, there was an amendment that was being offered that had been worked on with the Commissioner of Corrections. Do we have that amendment?
Not that I'm aware of. Does anyone else know of an amendment? Oh, I'm sorry. I didn't see if it did this.
I have an amendment here, 2021-0568H.
Who sponsored that amendment?
Representative Shapiro?
Is anyone here who signed on to that amendment? Can you tell us what the amendment did?
Incarceration under a suspended sentence, amend RSA 651-20I to read as follows. Any person sentenced to state prison for a minimum term of 6 years or more shall not bring a petition to suspend sentence until such person, it's been skipped, is within 12 months of serving 2/3 sentence to state prison for a minimum term of less than 6 years shall not bring a petition to suspend sentence until such a person has served at least 2/3 of the minimum sentence or the petition has been authorized by the sentencing court for the purposes of this subparagraph.
Thank you, Representative.
You're welcome.
Would the Commissioner like to testify? Absolutely.
Took a second to remember what we were talking about here, but this goes back to the first year of our term. There was some sort of technical problem, if I'm remembering correctly. We shelved it, and then for the first year, we're planning to readdress it this current year, but we're told it was folded into a Senate piece of legislation. Is that the path that this took? Am I correct in that?
I believe you are, but I don't have the bill, the Senate bill in front of me. Does anyone else have any information on that?
I do have a note that it was to be incorporated into SB 34.
So that, based upon that, the recommendation would be not recommended for any future legislation. That's our options today.
Understood. Would anyone like to make a motion at this time?
Can we take a look and see
Yeah,
if
go
it
ahead
actually
and Google it, yeah.
got to the finish line?
Look it up.
SB 34?
I'm not finding that. I'm not finding that in the search. Let me try the advanced search. I have it under the 2021 bills, That bill is relative to the definition of a controlled drug analog and prohibiting the sale or possession of synthetic urine and urine additives. And let's just take a look and see if it's there. Maybe 134? Oh, okay, yeah, I'll have a look.
Mr. Chairman? I do want to hear from the commissioner.
Yeah,
Go ahead and come up and give us your opinion on this.
Oh, look at that. Good morning, honorable members of the committee. For the record, my name is Helen Hanks. I'm the Commissioner of the Department of Corrections. And again, we did work collaboratively in 2021 to put forward a bill that the department could operate under. We certainly defer to the legislature whether you move forward with that. The opportunity it provides is that reference to 12 months so that someone could actually apply 12 months before their 2/3. And thus, if the sentencing judge and the prosecuting attorney don't object and concur, then they could be released at that 2/3 mark. And then we were working to balance the length of sentence as well as other concerns expressed by the victim and survivor community. So again, we are neutral, just being a partner in trying to bring forward a piece of legislation that we could work and operationalize.
As this legislation was proposed, were you in favor of the way it was drafted, or did you not?
In the initial proposal, we were not in favor. Is the amendment that was referenced that we worked on, and we could support that process.
Thank you.
You're welcome.
Go ahead.
Thank you, Mr. Chairman. And thank you for taking the question. Was there any resolve done by the Senate, and have we already passed some legislation on this at this point that you know of?
That's a great question, and to my understanding, nothing has passed associated with this concept.
Thank you.
You're welcome.
Go ahead.
Thank you, Mr. Chair. Would this apply to anyone, or would there be certain crimes that this would not apply to?
That is a great question, and by nature of our policy, we do have a list of crimes that are excluded from participating, and I don't have that in front of me today, and I would have to look back to the originating statute, but I don't believe it specifically excludes. It only requires the department to create a policy from which to review and make a recommendation to the sentencing court prior to proceeding.
Thank you.
You're welcome.
Thank you. Representative True.
Thank you, Mr. Chair, and thank you for taking my question. You said you didn't support the bill originally, I think you said. Originally, the change I saw on the amendment, which is not before us, changed from 18 months, within 18 months of serving 2/3 to 12 months. You didn't support the 18, but you did support the 12. Is that the big change?
That was, thank you for that question, and that was the change. And in fairness, without the two in front of me, I believe there was also some things around the actual sentence length and when, and I could be confusing this with another bill. So I appreciate the question.
Thank you.
Thank you. Thank you for your testimony. I'm going to ask Mr. Head from the court to come up and give us a quick update.
Good morning, Richard Head, Government Affairs Coordinator for the Judicial Branch. Senate Bill 134, which was an omnibus bill, does have the language with the 12 months in it. So Part 3 of that omnibus bill says is within 12 months of serving 2/3 of the minimum sentence. So that amendment did go through, it did pass, and has been signed last session.
Very good. That's all we need to know. Thank you. I'm going to recognize anyone who'd like to make a motion. Go ahead.
I would make the motion that this is not recommended for future legislation as it is already chaptered and signed into law.
And it's been seconded by Representative Harry Gathright. I think we've had enough discussion. This time the clerk will call the roll.
Representative Abbas. Vice Chairman Roy.
Yes.
Representative Welch. Representative Burt. Representative Rhodes.
Yes.
Representative Green. Yes. Clerk votes yes. Representative Testerman.
Yes.
Representative True.
Yes.
Representative Pratt.
Yes.
Representative Harriet Gathright.
Yes.
Representative Marston.
Yes.
Representative Panalakis. Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse. Representative Newman.
Yes.
Representative Bolden. Representative Conley.
Yes.
Representative Bradley. Representative Espitia. Okay, 14 yeas. Passes.
Okay. Unanimous. No, it's not recommended for future legislation. Okay, at this time, I'm going to close the work session on HB 205 and open the work session on HB 253, requiring law enforcement officers to use body cameras and establishing a grant program to assist law enforcement with agencies with purchase of body-worn cameras. I'll open by saying that a bill did pass, SB 401, or was it HB 401, that provided grant money for body cameras, and I believe that was signed into law as well. Does anyone have any more comments they'd like to make on that? Representative Conley.
Thank you. I just saw a post today from the state police indicating that they are rolling out their body-worn cameras and cruiser cameras. That's a great step. One part of this bill, and I was the prime sponsor, although it was actually Rennie Cushing's bill, was to support departments around the state that are not state police and to try to create a funding mechanism that gives them a way to offset those costs. I know Dover has done it out of its budget, and it's very expensive. So this bill clearly wasn't the solution, but I would hope that there maybe would be a solution to create a pool of money for local communities to pay for these and to.
Actually, the bill did. Was it SB or HB 401? I think the bill that created the if you recall, Representative Burt was opposed to it because it provided dash cams for the DOT. It also provided a pool of money for body cameras for local municipalities.
In that case, we are probably okay.
I think so. Agreed. The only thing that wasn't adopted was the mandate portion of it. But personally, I think that they're all coming along in due course. Anyone else wish to speak on this bill? Seeing no one, would anyone like to make a motion?
Sorry about that. I motion that this not move on for future legislation. Not
No.
recommended for future.
And a second? Seconded by Representative Welch. At this point, the clerk will call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt. Representative Rhodes. Representative Green. Clerk votes yes. Representative Testerman.
Yes.
Representative True.
Yes.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright.
Yes.
Representative Panalakis. Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Newman.
Yes.
Representative Bolden. Representative Conley. Representative Bradley. Representative Espitia. 14 yeas, 0 nays.
And the recommendation is adopted. At this time, I'll close the work session on HB 253 and open the work session on HB 526 relative to the fine for the sale of possession of cannabis. I'll start by just saying that we, as a body, produced numerous pieces of legislation regarding cannabis. And to the best of my knowledge, none of them made it out of the Senate alive, let alone to the governor's desk. I anticipate there'll be no shortage of them in the future. I don't necessarily see a need for this committee to recommend future legislation. I suspect it's going to self-generate. Would anyone else like to comment or talk about it? Representative Bourdonnais.
Thank you, Chair. I did look at the bill yesterday, and it seems like it's more of a first step of decriminalization of cannabis instead and without the commercialization. But there was one issue I had with it, and that is it did not make an age limit of 21. It was an age limit of 18. And I'm pretty sure that, like all other controlled substances, we are doing the state alcohol and tobacco, that cannabis should be for the same age. So I think that possibly that the bill that we offered 526 would be a great model for future legislation.
Thank you. Anyone else like to talk?
I respectfully disagree, and I will vote accordingly.
Okay. Representative Pratt. Recommend not to recommend. Representative, I'm sorry, you had Newman in front of you. I confused Muse.
I just want to note that eliminating the fines for personal possession seems to be one of the things that a lot of people do actually agree on. And in terms of the need for future legislation, I think that there's definitely a need to basically completely decriminalize personal possession. Whether this is the approach to do it is an entirely different question. So my question to the chair is: Are we supporting? Would we be supporting the approach in this particular bill by doing that, or could we make a broader recommendation? For example, that we support eliminating penalties for personal possession of marijuana.
I don't think we can make a recommendation broader than the actual legislation itself, because we would be recommending this bill for future legislation, not necessarily a policy. I think that we've had hours and hours of discussion in this committee, days regarding this, and we all pretty much know where we stand on it. I agree that there needs to be work done in that area. And as I said, I suspect there'll be no shortage of bills coming forward in the fall. And I just, in my opinion, I don't think that this committee as a policy body needs to weigh into it and prejudge it before we actually get bills in the fall. So I'm going to recognize Representative Pratt for a motion.
I recommend that we not recommend this for future legislation.
Seconded. I'm sorry, go ahead, Representative Harry-Gather.
Didn't we already have a motion?
No, he just talked it that way.
All right.
And the clerk will call the roll. Yes.
Representative Welch,
Yes.
Representative Burt, Representative Rhodes,
Yes.
Representative Green,
Yes.
clerk votes yes. Representative Testament,
Yes.
Representative True. Oh, okay. Representative Pratt,
Yes.
Representative Marston,
Yes.
Representative Harry Gathright,
Yes.
Representative Panalakis, Representative O'Hearn, Representative Bourdonnais,
No.
Representative Muse, Representative Newman,
Yes.
Representative Bolden, Representative Conley,
Yes.
Representative Bradley, Representative Espitia. 12 yeas, 2 nays.
The motion carries. The recommendation is adopted. With these, I do not believe there's a minority or majority report. I think it's just the committee report describing the decision. If one is needed, though, I will get back to Representative True or Representative Bourdonnais if we need a minority report. So at this point, I will close the work session on HB 526 and open the work session on HB 1105 relative to earned time credits. This one was a little more complicated. So let's open it up. Does anyone have anything they'd like to say on this bill? Representative Walsh.
I think the subject matter is something that's worth looking into. We started this process several years back. It's been somewhat successful. I can't remember what was actually in this bill, but I think the subject matter is worthy of future legislation. I don't know how we can do that, but
Thank you. I agree. I believe the debate on this was regarding courses that could be taken on a tablet and whether or not there was merit to that. I would like one more time to quickly hear from the commissioner, if she doesn't mind, on where that stands and where she sees it going.
Again, Helen Hanks, Commissioner of the Department of Corrections. For the record, I believe that was the concern brought forward by Ms. Sitek, that we were using the tablet-based programs. We used those quite effectively during COVID quarantining. Our teachers and educators used the learning management systems within that to push course materials from our Granite State High School. And we also used them on the courses referred to as the Correctional Rehabilitation Institute and the Peace Education Program in tandem. We have suspended those temporarily because we had a technological glitch on the Peace Education and Correctional Rehabilitation Institute, and we're working on the vendor on a new product. But we still continue to use those with our Granite State High School, just like individuals who take courses in the community can participate in their course online when we have units under quarantine. And we do occasionally still have units under quarantine. Go figure, COVID is still here.
If I may ask, if you could, there was some discussion or comments made regarding the ability of a prisoner or inmate to take numerous courses in one day and get good time for practically just laying in bed for a day and taking course after course. Can you give us a little input as far as how rigorous these are and whether that's a possibility?
I mean, I think someone could lay in bed just like a college student lays in bed and takes their courses. That's quite a description. But I go back to the individuals who are incarcerated have on average, a fifth grade education level. So if the course materials are so high that they can't understand them, then there's no point in delivering the materials. So for you or I, the rigor would not be as rigorous, but for someone with a fifth grade education, they do need to take time to go through them and sometimes don't understand some of the words. The Peace Education Program itself takes 5 hours, and the other Correctional Rehabilitation Institute courses take differing amounts of time. It was those in combination, not separately, that would have awarded people earned time credit. We deliver and provide earned time credit in numerous other areas the agency is prescribed by law. And I think that also has meaning here. People's meaningful participation in mental health treatment is actually one of the #1 areas people remit for earned time credit. And then obviously with the federal change in the Pell Grant, we'll have increased opportunities through post-secondary education, as well as attaining their high school diploma, their high school equivalency, and other career and technical education sets to earn time credit. And as the legislature outlined it, for attaining your high school diploma, you actually receive 120 days. And then you receive 60 days for additional vocational programming as outlined in law. And then our Family Connection Center program as well.
Thank you. I didn't mean to besmirch the the position of the inmate when they were actually taking the
No,
course.
it's okay.
I just, it was the vision that was being
Sure.
portrayed.
It looks shocking when you say it that way,
Yeah,
but
yeah,
when I think
but-
about someone going to college, I have
Absolutely.
young people in my family.
I don't think the legislature is concerned with their vertical or horizontal position.
Yeah.
But what the concern was is not necessarily the academic rigor as far as we would be concerned, because I do believe it should be appropriate to the education. But the amount of time that they had to invest was more the concern. Like they couldn't just burn through these like 4 or 5 a day or something like that.
I think that they could on the Correctional Rehabilitation Institute. Again, they're individuals who have almost 10 to 11 hours a day where they could be engaged for that amount of time. But I did put a pause on those, and in respect to the information that had already come to me prior to this legislation moving forward to evaluate them as the legislature asked me to under the statute. And as far as that opportunity, I would hasten to say if we remove the tablet as an opportunity to deliver our high school programming through the learning management system, it would actually slow the technological progress of the Department of Corrections in trying to deliver education.
I tend to agree. I don't think we should be limiting possibilities for anybody. Representative Newman.
This particular bill that's in front of us, did you or other people do work on this and come up with some solutions to that? And obviously this bill would need to be amended to make it the way that it needed to be to make sure they were getting the education, getting it properly with the proper constraints and rules and regulations. My question just goes to my confusion with kind of this process, because it's the first time that I've been involved with where we either recommended to have a bill be recommended to go forward, and obviously someone could write a whole new bill and it could go forward. In your experience with how it affected the corrections department, is it more beneficial or efficient to recommend something like a bill like this for legislation as opposed to someone starting from scratch and trying to rewrite the bill? I suppose they could copy this bill and submit it, but just your experience and thoughts on that.
I thank you for that question. And I've had the fortunate experience with being with the agency since the inception of earned time credit and the changes that have moved forward since then. I don't believe that section of law needs adjustment. So I wouldn't recommend changes to the earned time credit law. I think the department manages it quite efficiently, and I respect the feedback that was provided, but I don't think it would have taken legislation to ask the department to look at an area of concern. We would have dove right in.
Representative Conley.
Thank you, Mr. Chairman. Commissioner, you addressed just there the question that I had is, does the feedback you've received give you guidance that you can move forward with to address any concerns? And it sounds like with the pause, you're already doing so. That would negate the need for future legislation, or at least a recommendation from this committee.
I would agree. And in addition to, we also created a earned time credit review committee. So individuals who wanted to remit other programming not identified in law or specifically in policy, that it gets reviewed by a multidisciplinary corrections committee before it comes even to my consideration.
Okay. Representative Muse.
Thank you. During testimony, one of the things that we heard was that there are some issues around the notification process when people take these courses. So the impression that I got, I think from hearing, I think there was someone from the coalition who was here. There's an issue with victims being continually notified when these courses are completed. How does that work? I know you were here for that testimony. Has anything changed about your process? Do you maybe notify victims after 4 or 5 completions, or when they've actually accumulated time to have a sentence reduction? Or is this a process where people are just continually getting disturbing emails?
Representative Muse, that's a great question. So we're working, and we actually have a new administrator of victim services. Unfortunately, our previous one got a really great opportunity. We couldn't salvage her, but we have a new great human being in that capacity. We're still working on how do we try to bundle those. And a person, we're also moving forward with the Vine electronic notification system. So it's a self-service model for someone who wants victim notification to choose when they want to know. So I think those two things will help. I do think there was an expressed concern for people who were sentenced prior to the inception of the law in 2014. Attorney Head might have that date right. Going forward and still asking for this opportunity. And the question I asked was, is there some restriction you could put that if it wasn't on your minimus, then don't ask again? But I'm not the judiciary, so I could be interfering with people's due process privilege here.
Thank you.
Representative Rhodes.
Thank you, Mr. Chairman. So just to clarify, could you clarify whether or not the Victims Assistance Unit is on this committee or is not on this committee?
So the Victim Services Bureau within our agency is not on the committee to review earned time credit, but is part of the process that if someone is awarded earned time credit, that we make our statutory notification. And we're being responsive to those concerns, trying to see if we can bundle how that happens so they don't get, 4 or 5 notifications through the course of 6 months, but they get one notification that these 4 events happened because it changes someone's sentence structure.
Thank you. It sounds to me like the commissioner and the department has a good handle on this, and they've taken the feedback from the. Although I have just forgot again that Representative Gathright wanted to ask a question.
Well, it wasn't a question, but I did forget. Thank you, Commissioner Hanks.
You, Mike.
Sorry about that. Well, it's a comment, I think. I had a note here that when we had the hearing that Commissioner Hanks had testified and she was against the bill and she personally reviewed all the credits and releases for everyone that comes before him. And which I thought was really exceptionally great that something like that even occurs, that there's another eye that's really looking at everyone that wants to earn time credits and things of that nature. So for me, I don't believe that this is necessary and should be recommended.
Thank you. Is that a motion, Representative Gathright?
Absolutely.
And what would that motion be?
I motion that HB 1105 is not recommended for further release.
Seconded by Representative Wallace. And the clerk will call the roll.
Vice Chairman Roy,
Yes.
Representative Welch,
Yes.
Representative Burt, Representative Rhodes,
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testament.
Yes.
Representative True.
Yes.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harry Gathright.
Yes.
Representative Panalakis. Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Newman.
Yes.
Representative Bolden. Representative Conley.
Yes.
Representative Bradley. Representative Espitia. 14 yeas, 0 nays.
The motion carries, and the recommendation is not recommended for future legislation. At this point, I will close the public hearing on HB 1105 and open the public hearing on HB 1127 relative to the posthumous exonerations and annulments. And this bill, if I recall, was also one from Representative Cushing, and it had to do with, I believe, someone who was wrongly accused of witchcraft in the 1600s or 1700s, I believe. I believe that there were some questions with regard to whether someone would have standing to bring such a motion to the court. And I also believe that we discussed that the executive has the plenary power to grant pardons and actually correct this record much easier than a court process would. So anyone have any comments or wish to discuss this? Representative Welch?
Yes, realizing that whatever we vote today isn't going to make any difference once the elections take place and new people come in. I think this should not be recommended because the bill that we heard, the sentence came from the Bay State. So there's nothing we could have done about it. So I would be recognized for a motion that this not be recommended for future legislation.
I'm going to hold that up and let anyone else who wishes to speak talk first. Representative Harry Gathray.
I just want to mention that we verified that the judge that made the decision in the case was New Hampshire and not Massachusetts, because that was brought up in the hearing, and you can go online, you can see all the documentation, and everything was handled in New Hampshire.
Was it not at the time though still part of Massachusetts? I believe.
That's not what it says. It says it was New Hampshire.
Okay, well, I guess that's really neither here nor there as far as whether or not we decide to move forward. Representative Muse.
Yes, I just wanted to point out that this isn't the first time this has come up in the legislature. With HB2 last year, one of the things that we did as a body was that we basically forgave the people who violated the governor's COVID executive orders. Now, the governor signed the bill, and that's why it went into law. But if we were to pass a bill like this in the legislature, the governor would also be required to sign it into law before it becomes law. So while the powers of pardoning are reserved for the governor, I went through the law pretty carefully. The governor and the executive council are the folks who are in charge of pardons. What we're talking about here isn't the pardon of a person who is still alive. We're talking about creating an injustice, we're talking about fixing an injustice. And this is something that is within our power. I do think that this is a bill that we should consider again, because I mean, I think one of the reasons why a lot of us are here is to make sure that that wherever we can fix injustice when we see it. And if you look at these particular cases, having people convicted of witchcraft and people unfairly accused of crimes that when we look back, there's a lot of doubt about who was actually in error here. Was it the person who was accused of the crime, or was it some of the officials in government who went after that person? So I don't think that this thing is necessarily cut and dry, but I would like to see it come back in future legislation.
Representative Testament.
What worries me about this one, it's a lot like tearing down statues that we seem to be in vogue right now of people who possibly had some long past what we think to be a onerous type of activity. And things that happened in the past are not good or bad. I have relatives, my wife were incarcerated in World War II. We're not looking to basically condemn President Roosevelt for having passed a law. It happened. It's over with. Let's call it quits.
Thank you. I'll say this. It's obvious from the record that Miss Goody was wrongfully accused and sentenced. And we cannot bind a future legislature, but we can make a recommendation as a committee that while this would not erase or change history, what it would do is acknowledge the current body's recognition of a past wrong. So I don't see the harm in recommending it for future legislation. And if the next body comes in and decides to do so, but I think as a policy statement from this committee, it would be a good move for us to recognize that there was an injustice done here. And it wouldn't change history. It would still be there. As a matter of fact, it would add to the history that we actually saw and recognized and wanted to correct it. So I would recognize Representative Muse for a motion.
I move that HB 1127 be recommended for future legislation.
Second, anybody? Seconded by Representative Bourdonnais. Clerk will call the roll.
Vice Chairman Roy,
I vote yes.
Representative Welch,
Yes, reluctantly.
Representative Burt, Representative Rhodes,
Yes.
Representative Green.
No.
Clerk votes yes. Representative Testament.
No.
Representative True.
Nay.
Representative Pratt.
No.
Representative Marston.
Yes.
Representative Harriet Gathright.
Yes.
Representative Panelakis. Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Newman.
Yes.
Representative Bolden. Representative Conley.
Yes.
Representative Bradley. Representative Espitia. 10 yeas, 4 nays. It's recommended.
And for the record, I would just like to add that I support this also in part because of the many years of hard work that the late Representative Cushing and many attempts he made to right this wrong. And that's part of the reason I supported this bill. So, in his honor. At this point, I will close the public hearing. HB, what is it, 1105? 1127. And open the public hearing, the work session on HB 1232, reducing the penalty for first-time drug possession and repealing certain mandatory minimum sentences. I'm going to say the same thing I said on the previous marijuana bill. As a committee, I don't think we should be making recommendations on things that are sure to come before us in the fall and prejudging. I think we should just wait and see what comes to us and hear the bills as they come on their own merits. I think enough bills have come out of this committee, and our position has been pretty clear on them, and they just haven't seemed to get any traction. So I'm recommending that we just wait and see what comes to us and deal with it as it gets here. Anyone else wish to comment?
Is that a recommendation? I'll second it.
I can as chair. Representative Casey.
Mr. Chairman, just I agree that this will be back, I'm sure. The fact that this committee has recommended at least one version of this bill near unanimously in the first year of our term suggests we support the concept and should give it that nudge moving forward. I know that this is not the bill that left the committee in that way, but there's different ways up the mountain. And I think we're going to have to come up with a new approach, seeing as the other ones have failed. But as a concept, I think it's something that the committee supports, and we should give it a recommendation of passage.
Representative Testament.
I disagree. This bit about first offense, it's the first offense they were caught at. If anybody believes the people who are picked up on a first offense of something, it's the first time they've used drugs. They're using them too. This to me is a mistake.
Representative Walsh.
Yes, this bill, the first offense drug possession, I don't support at all. But repealing some of the mandatory minimum sentences, I've worked on that before, and I think sometimes that would be a good thing. So I have mixed feelings about that particular bill, and I think if we were to recommend this for future legislation, it kind of gives a signal that we would approve of it. So I would not do that.
Representative Rhodes.
Thank you, Mr. Chairman. I think I echo a lot of what Representative Welch is saying, and I think one of the things that we need to remember is a lot of times, you know, the these charges are pled down. So it tends to get watered down in what was actually what the person was arrested for and what they may or may not have actually been charged with. And I think that's something we need to consider as well.
Representative Newman.
Thank you, Mr. Chair. I think we have judges because they judge things, because they take things in front of them and consider all the circumstances. I think the mandatory minimums tie the hands of judges, in some case unfairly and unnecessarily, with the results to the person that's charged. So I'm opposed to mandatory minimum sentences, so therefore I think that we need to recommend this bill for future consideration.
Representative Green.
I think it gives the people a false sensation that if they get a light sentence for the first time possession, that they're going to get a light sentence from there on too. So I would like to see it ITL myself.
Would you like to make a motion?
I make a motion to ITL.
You mean not recommended for future legislation?
Yes.
Anyone second? Representative Pratt seconds.
I'll second.
Clerk will call the roll.
Chairman Abbas.
Can we just read the title? I'm sorry. Could we just reread the title of this bill?
Yeah, I'll read it. Go ahead. HB 1232, reducing the penalty for first offense drug possession, repealing certain mandatory minimum sentences. The motion on the floor is not recommended for future legislation. And the vote is to you.
And I have to go first?
You can wait.
I
Yeah, he would normally go last, so
That's
go ahead.
correct. Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt. Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testament.
Yes.
Representative True.
Nay.
Representative Pratt.
Yes.
Representative Marston. Representative Harriet Gathright.
Yes.
Representative Panalakis. Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse. Representative Newman. Representative Bolden. Representative Conley. Representative Bradley. Representative Espitia. Chairman Abbas.
chair votes yes.
11 yeas, 4 nays.
Okay, it's back. The motion carries, not recommended for future legislation. And I will at this time close the work session on HB 1232 and open the work session on HB 1281. Would the chair like to take over? Or? Okay, we will continue. Relative to access to firearms confiscated from a person who is subject to a protective order, I'll open by saying this was actually my bill. It was brought forward at the request of a constituent. It was designed to allow people who had restraining orders to dispose of their firearms in a more cost-effective manner than currently exists. However, after speaking with representatives from the Domestic Violence Coalition, I actually recommended that my own bill be sent to interim study, and I think there possibly could be some room to work and do something on it, but at this time it's, in my opinion, not specific enough to recommend for future legislation until I have, or whoever would like to speak with and work with the Domestic Violence Coalition. But at this point, out of respect for their concerns, I would recommend that we not recommend this for future legislation. Would anyone else like to speak? Representative Bourdonnais.
Thank you, Mr. Chairman. I've been thinking about this bill because I understand that having your firearms kept by law enforcement it can be an expensive operation, and the problem of having just anybody monitor somebody's or keep somebody's firearms is problematic as well, because how can they be trusted not to let their friend borrow their firearm? But on the drive over this morning, I said, how could we do this? And it would have to be someone that is licensed or bonded, that they already are familiar with firearms. And I'm thinking that a lot of people belong to gun ranges, that gun ranges would be a good party to be a keeper of firearms that have been sequestered. And that's all I have to say.
And I appreciate the thought you put into that, and I'd be happy to discuss it with you over the off season. Representative Welch.
Yes, when Ed Brown over in, I think it was Plainsville, when he was arrested, he had 35 firearms, and they were put in the custody of Riley's gun shop. Now, it still cost him for the storage, but the complaint originally that we had about this situation was if they're stored at the police stations, there's no guarantee they're going to not rust and so forth, and some of these guns are kind of expensive. So it's a situation that needs to have an answer at some point.
Microphone work. Okay. I tend to agree with you. I think that the subject matter of this is so delicate that it needs to be worked on with a scalpel, and it's too complicated for a blanket recommendation, in my opinion, of future legislation at this point. However, I will be bringing something forward after consulting with all the interested stakeholders. Representative Marston.
Thank you, Mr. Chairman. My only question in this bill is it's talking about a relative access to firearms. So is that saying that we confiscated them, but you can have an access to them? Is that, I'm confused in that sense.
The intent was so that a relative could pick up the firearms for you and either hold them or dispose of them, but you would not have access to them. But as I said, it definitely needs some wordsmithing and research. So, Representative Abbas.
Thank you, Mr. Chairman. So what I understood too is there's nothing preventing anyone from selling or transferring title if in the custody of law enforcement. It can still be done unless it's evidence in a crime. But if it's just simply because of in a domestic violence restraining order, they're not going to be prohibited from selling them. But for any issues involving domestic violence, just that everyone knows, and Representative Roy and I we were at that meeting, there was a task force that came out, and the court system published. It's 150 pages. I recommend everyone take a look at it. I'll have the committee assistant email a copy of that to everyone. It was really comprehensive. So any issues on that subject, including this, I would kind of focus on what the task force recommendations were. Doesn't mean we have to follow them, but just put that into consideration.
Agreed, and that was also part of my thinking. Representative Green.
In Massachusetts, there's a very high storage charges. By the time everything is settled and done, they own the guns. The only way I would consider something like this if there's no charges at all.
Yeah, agreed. And that was part of my fear and the constituents' fear, is that we would end up with a system such as that, where once they were gone, you may as well forget them. And also, my intent was so that the defendant would actually have access to sell them should he require or she require the funds to pay for their counsel moving forward. That's liquid assets tied up. So there is a lot of angles to look at this, and like I said, I think it will require some definite research. I can't make a motion. Would anyone else like to make a motion? Representative Walsh.
I make a motion that House Bill 1281 not be recommended for future legislation.
I second that.
Vice Chairman Roy,
Yes.
Representative Welch,
Yes.
Representative Burt, Representative Rhodes, Representative Green. Clerk votes yes. Representative Testament, Representative True,
Yes.
Representative Pratt,
Yes.
Representative Marston,
Yes.
Representative Harriet Gathright,
Yes.
Representative Panalakis, Representative O'Hearn, Representative Bourdonnais,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Bolden, Representative Conley, Representative Bradley, Representative Espetia, Representative Abbas,
Chair votes yes.
15 to zip.
The recommendation of not recommended for future legislation is adopted. I hereby close the work session on HB 1281, open the work session on SB 292. I'll also address this one. This should be really quick. This was brought forward at the request of parole probation as they were having difficulty coordinating notifications to them if one of their parolees or probationers were arrested. Based on my previous law enforcement experience, I knew that there was an electronic way to do this much quicker. I met with the state police, parole, probation, and the IT folks, and they actually were able to figure out a simple, hopefully simple fix, whereby if someone runs the record, arrests, or has any interaction with a parolee or probation officer that's entered into the computer system, the probation or parole would be automatically notified immediately. So when they came into work the next day, they would have a notice that their person was run by somebody that they could follow up. So based on that, at the request of probation and parole, I would recommend that we do not move forward with future legislation on this. Anyone wish to comment? Representative Marston.
Thank you, Mr. Chairman. Is this the possibility, though, that this will come forward, or has it been already done something because of the Senate and going through the whole process?
Actually, it was accomplished without legislation. They were able to work with the existing system they had and connected everybody, so it's no longer an issue. So they don't need legislation.
Thank you.
Would someone like to make a motion for me, please? Representative Marston.
I'll motion that the SB 292 be not recommended for future legislation.
Representative Harry Gathright seconds. Clerk will call the roll.
Vice Chairman Roy,
Yes.
Representative Welch,
Yes.
Representative Burt, Representative Rhodes,
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testament. Yes. Representative True.
Yes.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright.
Yes.
Representative Panalakis. Representative O'Hearn. Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Newman.
Yes.
Representative Bolden. Representative Conley. Representative Bradley. Representative Espetia. Chairman Abbas.
Chair votes yes.
15 to 0.
And the recommendation of not recommending future legislation is adopted. And I hereby close the work session on HB 292. I'd like to thank everyone for a great couple of years, and I will let Representative Chairman Abbas speak. What? Oh, what do you got? I was going to do them.
You're gonna do all?
Yeah. And I was going to give everybody an early Christmas present. I'm going to go ahead and do all the record reports for this. So, everyone enjoy your summer, and good luck in all your races. God bless. Godspeed.
Representative Welch, you want to address the room?
Well, I say a couple of words. You know, I'm leaving. I'm not coming back. I will be back on occasion, I think, to testify on some bills. But I was the first chairman when this committee was first formed, and the work is important, and we really need to buckle down and dig into these bills as we get them. Some of them are simple. Some of them are, as the vice chairman has indicated, very complicated. So I wish you all well, and I'll see you on veto day.
And I will not hesitate to pick your brain next year. Thank you very much for your service, and it's been a joy working with you. And the committee is now adjourned.